court today on Cure Insurance's motion for a entry of a default against Ms. Canosa and Mr. Kimbrell. And I would ask counsel for Cure, would you counsel for the insurance company? Would you place your appearance on the record?
Good morning, Your Honor. Charles Torno.
Bluetooth connected.
P73998 on behalf of Cure.
Very good. Thank you, Mr. Tornow. And I do see, it looks like either Mr. Kimbrell or perhaps Ms. Canosa or both are connected here on Zoom. Who do we have present for defendants? And you're going to have to unmute Kimbrell, Canosa connection there. You're going to have to hit that red microphone so I can hear you.
And start. There we go, I think.
Yes, I now can hear you. Who do I have? Is it Mr. Kimbrell?
The case opens inside a courtroom where an insurance company is requesting a default judgment against two defendants. The judge calls the session to order and asks the insurance company's lawyer to officially introduce himself. At the same time, he notices that the defendants have joined the hearing through Zoom, setting the stage for a tense legal discussion.
Yes, this is Mr. Kimbrell and my grandmother, Diane Canosa.
All right. Would you state and spell your full name for the record, please, Mr. Kimbrell?
Yes. Andrew Kimbrell, Kimbrell.
All right. Thank you, sir. Mr. Kimbrell, have you retained counsel to represent you in this case by chance?
No, I haven't.
Okay. And do you understand the kind of the mechanics of this case in that, Citizens United has served you with papers that say, hey, we don't cover you under our policy and further, are going to cancel the policy. I think that named maybe Miss Canosa, your grandma, as the insured, retroactively because she didn't disclose that you were living with them at the time of the application. Do you kind of understand what's happening?
The judge asks who is present on behalf of the defendants. A young man, Andrew Kimbrell, speaks up along with his grandmother, Diane Canosa. They confirm their identities, clearly nervous but ready to explain their side of the story without any legal representation.
Yeah, I understand what's happening, and she is aware of it as well. However, it's more. I believe it's more of a misunderstanding than anything. My grandmother would like to speak, or did you still have more to say?
No, that's okay. I'll hear from Ms. Canosa as well. Ms. Canosa, would you state and spell your full name for the record, please?
Diana Shirley Canosa.
Could you spell that for me, please, ma'am?
K-A-N-O-Z as in zebra, A.
Thank you, ma'am. And Ms. Canosa, do you understand the nature of the case that's been filed against you by your former insurer, at least Citizens United Reciprocal Exchange?
Yes.
Okay. And have you retained counsel to represent you in the case by chance?
The judge quickly realizes that neither of them has hired an attorney. He warns them that insurance cases like this are complicated and difficult to handle alone. Despite this, both defendants admit they plan to manage everything themselves, not fully understanding the seriousness of the situation.
No, I haven't, because I figured that I would take care of it myself.
Okay, well, that's a very hard thing to do in a complicated insurance case in court like this. Not impossible, but pretty darn hard to do. And I mean, you're in a position now because you haven't responded to the insurance company where they're asking me to say, Judge, everything that we said in the complaint is true because we don't have any answers. And that's exactly what the law does. Is that if you don't answer within the requisite amount of time.
I did answer.
Oh,
sure.
You filed an answer in the complaint?
Yeah, we've been in correspondence with them pretty much up to just until the last 1 or 2 months. We had been communicating with them regularly.
It was on the phone.
Yeah.
Yes,
Well,
It was on the phone, and they documented it. They had a recording of it all.
The judge explains the heart of the case. The insurance company claims that the policy should be canceled because important information was not disclosed. Specifically, they argue that Andrew was living in the house but was not listed in the insurance application.
Sure. Now, let me clarify for you, though. When I say answer in court, you're exactly right. Answer in everyday life means I answered the phone or I responded to the email. And answer in court means I filed a paper that says, I deny their allegation number one is true. I deny their allegation number two is true. And then it's signed by the party, that's filing the document at the end of it. It's a very specific term, as all terms are, with legal filings and filings in court. And that's exactly the reason why I'd say, if you want to mount a credible defense to what the insurance company is saying here, the most effective way, the only effective way in my estimation, would be to retain an attorney. You could either hire an attorney at your own cost or possibly access an attorney through
Andrew responds calmly, saying that the situation is being misunderstood. He insists that both he and his grandmother are aware of the issue and believe it's not as serious as the insurance company is making it seem.
A no charge. If you qualified for legal aid, you could try to get a civil attorney to represent you through legal aid, and they might weigh in on your behalf and agree to represent you on this matter.
At the time, I thought when they called me, there was a number of calls to the claims department and to different people that I talked to at the insurance company, and they told me that it was on a recording. They told me that everything I say was documented. So I just never thought I had to put it in writing. I mean, I just figured they have it all my messages and talk to a live person, but it was
enough. We were being sued up until the very last.
Yeah, we didn't know, and then what they did was, apparently I didn't have any insurance, not knowing I didn't have any insurance.
The conversation takes a turn when the defendants say they had been communicating with the insurance company regularly. They believed phone calls and conversations were enough to respond to the case.
I still paid them money for December, January, and February. They still charged me, and I paid my insurance company, but I didn't know I didn't have any insurance. I paid them for nothing, and they said they returned my money to me, but they never did.
You haven't seen that check yet. Well, all of those would be very valid things that you could raise via an attorney. But the way you're going about it, though the insurance company does record and, you're correct, all that information would be in their claims file. It has exactly zero visibility in the legal file that's in front of me, unless the insurance company puts it in there. And I can guarantee you if it's not against if it's against the entrance of what they're trying to say, it won't make its way in front of me. So you really do need to secure legal representation if you want to defend this.
The judge clarifies a critical legal point. Talking on the phone is not the same as filing an official response in court. In legal terms, an answer must be a written document submitted properly. Without it, the court assumes the insurance company's claims are true.
Mr. Turno, anything to add to that?
No, just that we served the complaint personally to each of them. And that went through on May 20th last year. Their defaults were served July 3rd last year. This is the first time, at least, that our office has heard from them that they showed up today.
Yeah, I understand. Knowing commonly, of course, they're talking to the insurance company. They don't recognize you. You're not the insurance agent or the people they've dealt with in the past. So, right, that probably explains that. So, I think, the other tricky, sticky part of this here is it might seem like Ms. Canosa and Mr. Kimbrell, you could be represented by the same lawyer. However, that also might not be true, and that your interests might diverge at some point, and you might have to have separate attorneys. However, I'd recommend trying to get.
The judge emphasizes that all their conversations with the insurance company hold no weight in court unless formally submitted. This misunderstanding has placed them at serious risk of losing the case without even presenting their side.
Ms. Canosa, since you're the alleged policyholder, I guess it would make most sense for you to be the first one to request an attorney, for example, if you're going to go to legal aid. And then, initially the person could evaluate whether they can represent the both of you or not. And then I would, if failing at legal aid, I guess I would reach out to an attorney who does civil insurance work, who you could hire. That would be quite expensive. So,
why is that? Could that be a conflict of interest to have the same attorney?
Yeah, it could be because the basic allegation here is that the reason the policy was canceled was because Mr. Kimbrell lived with you at the time of your application for insurance, and that application didn't say, oh, by the way, my grandson lives with me at the house, and they're saying that's the kind of misrepresentation that allows them to cancel.
Yeah.
Diane raises a shocking concern. She continued paying insurance premiums for months without knowing her policy had been canceled. She claims the company took her money but never returned it, leaving her feeling misled and frustrated.
Yeah, which wasn't true. Which at the time was not true.
Yeah, no, and that's exactly why you do need to have an attorney to represent you in this matter. However, we are at the point, when they're requesting a default judgment, this is the proverbial point of in a case where you need to fish or cut bait, as they say. So what I'm going to do, Ms. Canosa, Mr. Kimbrell, is I will reset this for another date, a month in the future. During that time, which I expect you to go and make some efforts to retain an attorney. If you're successful, obviously the attorney will appear with you at the next hearing. If not, then do save the documentation of your efforts to get an attorney so I can evaluate that and determine where to go next time. Because if I, declare this default judgment in the favor of the insurance company, you have lost the case.
The judge strongly advises both defendants to hire an attorney or seek legal aid. He explains that without proper legal representation, they have almost no chance of defending themselves effectively against the insurance company.
In court before you even had a chance to get out of the blocks. So I am going to, at this time, grant a 30-day. I'll reset this in 30 days. So I'll adjourn the hearing on the default for 30 days for the purpose of you obtaining an attorney.
What happens?
What are they seeking in this judgment?
Well, if they win, and I can't, give you a full range of legal advice, but the certainty is that insurance policy then would be canceled out. What they're asking for is called from the date you signed it, from the date you tried to get insurance and made that false representation, there would be no insurance. In a legal sense, that means that you would be uninsured at the time of the accident, and I think, Mr. Kimbrell, you may have been the involved driver here. That would mean you were uninsured, and it would trigger.
Another complication arises. The judge explains that Andrew and his grandmother may not even be able to share the same lawyer. Their interests could conflict, especially since the case revolves around whether Andrew was living in the house at the time.
That Michigan law, it talks about what happens to uninsured drivers, but part of it is you could be, of course, personally liable for any amounts found against you.
Would that have pertain to anything with criminal court, or would it stay in civil court?
This is purely in civil court. There are no criminal charges attached to this at this time. There are, of course, you do have to have insurance and yada, 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 but there's that's not implicated here. This is all about money.
Everything's about money.
Well, that is the nature of capitalist society. And the other thing is, for both of your perspectives, well, what could be the worst? Well, you get saddled with a full range of damages and medical bills in a case like this, which could easily, of course, exceeded, $250,000, $500,000, and that's a judgment against you that basically sits there financially for the rest of your life. So,
There,
anything
there
to-
was
The judge outlines the real danger. If the insurance company wins, the policy will be canceled retroactively. This means Andrew could be considered uninsured at the time of an accident, making him personally responsible for all damages.
Sir, I'm sorry. There was no medical bills that we're aware. We didn't file any medical bills.
No, it could
Yeah.
be the other driver in the case that was injured, suing you. So that's the unknown piece here. Mr.
What-
Tornado, do you want to add something to that?
Yeah.
I had a quick question, Your Honor. And what would my legal grounds be, for like countersuing or something like that? Because I did get injured. I had my hip broken in 2 places.
But we didn't.
I'm in no position to advise you on that. You could have, if the insurance was in effect and covered you, potentially you'd have a claim against the insurance company for any medical expenses you incurred. But you'd want to. The key for you there, Mr. Kimbrell, is you might have enough grounds to go to a private attorney.
The judge warns that damages in such cases can reach hundreds of thousands of dollars. Medical bills and liability claims could follow them for the rest of their lives, turning this case into a long-term financial burden.
And that might be a case that they would handle for you to recover those medical bills, because there are provisions that they can get their attorney fees from the insurance company. So I'd advise you to consult with a private, no-fault auto attorney on the matter.
I definitely will.
Can I ask a couple questions here?
Yep, go ahead, Ms. Canosa.
They got on my insurance thing that I was in a number of accidents. I haven't been in an accident in 30 years, almost 30 years.
Yeah,
I don't
I can't speak to that, Ms. Canosa. I have no idea, where they
Yeah,
get the information or how that impacts the case.
And that's one thing. And then I never received. They charged me. I paid my.
Instead of ruling immediately, the judge gives them a 30-day extension. This is their final chance to find a lawyer and prepare a proper defense. Without action, a default judgment could end the case against them.